See, I had a first 43 years of law practice. I don't think I've ever had this situation before with a client that came to see me yesterday, and I had done her trust years ago, and she left everything equal to her kids, and she was coming to me yesterday, and she wanted to amend her trust. Now, most of the times when a parents pass away, they leave everything equal to their adult children. When mom passes away, everything gets dispersed out to those adult children under the trust. In a few months, and bills are paid, final tax return is paid, and it's over with, that trust. Sometimes when mom passes away, their wealth for a particular child stays in trust because that child has addiction issues, alcohol issues, or is a spendthrift. So mom wants to have that money doled out to them over the child's lifetime. Yesterday, mom was coming to me and saying that her son is in a polyamorous relationship, and she does not approve of it.
What is that?
It means that
I don't even know
his
what that means.
wife has multiple men in her life, and at least one of them is living at the home with his husband and wife. And
Okay.
his birthday was recently, and the wife invited, and at her husband's birthday party, she's inviting all the other men in her life to come to his birthday party. I wish the listeners could see the look on your face.
Okay.
So client did not approve of that.
Mm-hmm.
So she said, Tom, he can still get his share, but no, it's going to be held in trust.
Mm.
And what was we had a discussion about it because
One
when
minute.
we do it, I tell you what, we're going to finish this on the other side of the break.
Okay.
Because the story goes on for a while.
Okay.
You want it?
Wow.
We got your attention now.
Oh, yes. Okay.
All right, folks. Chris, I've been doing estate planning for 43 years. I had a very unusual, first time ever consult yesterday, and it was from a lady, that existing client. I did her trust for her a few years ago. Most of the times when people are doing living trust for the purpose of avoiding probate, so that when mom passes away, the successor trustee pays the final creditors, doctors, hospitals, credit cards, files a final income tax for mom, disperses the money out to all the kids, and the trust is over with after a few months.
Mm-hmm.
Sometimes when clients have spendthrift children or children with addiction issues, alcohol or drugs, the parent will say, okay, instead of getting this child getting their share outright, we want this child's share held in trust, potentially forever, and have that money doled out to them. But one of my other kids will be the trustee of the money and make the decision about how to dole that money out to the child for their best interest. And that's not unusual.
Right.
And say it again. If you are listening right now and you have a child with addiction issues, alcohol or drugs, man, you are not alone. Christy, you and I, as many clients as we talk to, it is a very, very pervasive thing going on in the United States right now.
More than ever.
So don't think you're alone.
Correct.
So the client came to me yesterday, and her issue with her son was that he's involved in a polyamorous relationship. Of course, I'd heard that word before, but she further defined it for me. And that is her son's wife has multiple men and lovers in her life. In fact, one of those men is living with them. They turned the dining room into his bedroom.
Oh, my gosh.
The wife had a birthday party for her husband, my client's son, and invited all the other men in her life to that birthday party. And my client is just not going for it. She's not going to have it. So she decided that rather than that son get his share outright free of trust when she passes away, she wants his share held in trust to be managed by one of her other sons. And I started talking to her about, okay, how are we going to define when and if he gets this money?
Right.
When we're holding a money for a child because his addiction issues,
Correct.
we might have language that says, okay, if the child's been sober for 1 year, then he gets his money. Or if the child has matured and now is handling his money better, he's no longer a spendthrift, okay, he can have his money outright free of trust. I go, well, how do you define this?
Right.
And I said, we can't really define it that if he divorces that woman, because he could divorce her and they could just continue on living this lifestyle.
Right.
Which is, hey, different strokes for different folks. Okay, I'm not condemning it. I'm just saying my client was not going to go for it.
Right.
And so that's not going to work. And trying to define, can't have any contact with her for a year. And she said, just, Tom, I'm going to talk to my older son. He's going to be the successor trustee. He knows the way I feel about it. I'm just going to leave it completely up to him.
Mm-hmm.
So that's the way we left it. It's completely up to her surviving adult son to make a decision when this other son would get his share, if ever, based on mom's concerns about the polyamorous relationship.
That is something that I have never heard before. Obviously, I have not been practicing as long as you. However, I would say that under the circumstances, probably the best way to do it is the way that you and the client came to the conclusion.
Mm-hmm.
Let the child or, by the way, with the trust, whoever the successor trustee, that may be another adult child or it may be somebody else in the family. There are situations where we do that the successor trustee, but the wording is put in the trust that the particular share going to any person that is to be held, that there is language, sometimes that language is giving the successor trustee the ability to use their own good judgment.
Exactly. Typically, a trust for a spendthrift or an addicted child or even a minor child, it would say give the beneficiary as much as he or she needs, and that just gives a whole lot of discretion to the successor trustee. I don't even think we could do that for this polyamorous relationship child. It's just going to say give it to him when you think it's right, based on
absolutely.
my feelings.
Right.
When we have a spendthrift child, it says give the child as much as he needs, but we always encourage the client to say, okay, give it how much. If you passed away, how much would you want the successor trustee to give your spendthrift child per month? Let's just say $2,000 a month, and then the trust was for the spendthrift child to say, successor trustee, give that child $2,000 a month and as much as he needs.
Exactly.
And that way the spendthrift child is not calling the successor trustee every day and saying, I need money, I need money, I need money. The successor trustee can say, look, mom's trust says give you $2,000 a month. Don't call me again. So there's, for spendthrift children with addictions, we've handled those all the time. There's some great ways to handle it. I've just never handled it for a polyamorous relationship child before.
Exactly. And to add to what you're saying, most of the time we are helping the client to define and to give specific criteria. Why? Because the specific criteria, whether it's a dollar amount per month or quarter or yearly, and specific criteria helps the successor trustee under most circumstances. What we're saying here is that giving the successor trustee more of control to do what they feel is going to be right at that time will work for this situation. However, most of the time that is not what we are. I think that's really the point, is that most of the time we are really guiding them to give specific instructions, more detailed instructions and criteria, so that it is better for everybody.
Over the years, I've had a lot of people say, Tom, when I pass away, this particular child, let's call him Bill, I don't want Bill's share given to Bill outright. I want Bill's share held in trust and managed on his behalf and doled out to him. I go, okay, great. Who's going to be the successor trustee? Who's going to make those decisions for you when you pass away?
Correct.
I don't have anybody. Or, I've got 2 kids and they hate each other. Who's going to do that job then? They go, okay, well, that's not going to work because I got nobody that could do that for me.
Correct.
Would be willing to, nobody I'd want to put into that position. Because if mom has a trust and they name you as child A as successor trustee to manage the money on behalf of child B, guess who's going to have a real conflict, going to be butting heads over that, because child B is going to be very upset that he didn't get his share outright and child A is managing it for him.
That's why we will almost always advise the client to be very specific.
Put as much detail in there as possible, or guidance in there as possible, telling child A as much guidance as possible how to dole this money out to
One
the child.
minute.
Because it means it was the parent giving that instruction, and it's not the successor trustee, whoever that is, that's having, because then there can be more conflict, and that's the point. But in this situation, what we're saying, this is the very unique situation where it would likely be better to give more control to the successor trustee for at that time.
All right. Hey, folks, my name is Tom Olson. The name of the show is Olson on Law. We're going to